you just finished trial. You got a jury verdict, but the client is not happy. What are the options at this point?
The verdict is in, and for some reason the client is dissatisfied with it. Appeal is always an option. You have the right to appeal to the Court of Appeals in Iowa, basically for any reason. It's not to say it's a good idea to do it, but you do have the absolute right to appeal to the Court of Appeals. What I look at is there some type of legal error that you can hang your hat on? Because I am a very strong believer in you do not file appeals because you're disappointed in the dollar amount. And with no intended disrespect to anybody, but I refer to those as boo-hoo appeals. And that's,
I'm disappointed it's not enough.
Or if you're the defense,
I'm disappointed it's too much.
Those are boo-hoo appeals, and you're almost never going to have any luck with those. Those are, in my opinion, a complete waste of time. On the other hand, if you can hang your hat on a legal error, maybe the judge gave a jury instruction that is inconsistent with law. That would be something you can hang your hat on because that'll prejudice your case. So now you appeal to the Court of Appeals, you show them the instruction that was given, you show them what the law is, and if you convince them you're right, you're going to get a new trial. And the idea is you come back for the second trial and you get a verdict that's not tainted by the legal error. So the legal error could be in a ruling that's made, for example, on whether a witness gets to testify on a certain subject matter, sometimes on whether a witness gets to testify at all. It could have to do with maybe some inflammatory subject that should be excluded from a trial. For example, every single motorcycle case I have ever tried where the injured biker wasn't wearing a helmet, we always make a motion before trial to exclude any evidence that the biker wasn't wearing a helmet because it's completely irrelevant. There's no law in Iowa saying you have to wear a helmet. And we've won that motion every single time. But if you don't make the motion, that evidence will come in and it'll kill your case. If I ever had a case where a judge overruled that motion and evidence came into the trial that the biker wasn't wearing a helmet at the time of the crash, I'm going to appeal that and I'm going to get a new trial. So that would be a really good example of a legitimate reason to appeal with a legal error that tainted the outcome of the case.
We haven't covered Additer or Remittiter.
Yeah, so Additer and Remittiter, it's the first step you take before appealing. So if you've got a specific legal principle you can hang your hat on where an element of damages didn't get included that by law should have been included, you can make a motion to the judge for Additer, and the judge is either going to grant it or deny it, and if he or she denies it, then you can appeal. Additer is,
hey, the verdict isn't enough, Judge. Add some to it.
That's Additer. And the flip side is the defense says,
Gee, Judge, that verdict is too much. You should make them remit or give some of it back.
And the judge may say,
okay, if you don't accept my Additer, my adding to the verdict, then you're going to have to appeal.
It's super, super rare. I mean, I frankly have never had Additer or Remittiter work in a case. I don't think I've ever even requested Additer. I know that one of the lawyers in our firm did that once upon a time and got an Additer, which was highly, highly unusual. But it's a procedure that's out there for extreme situations where a mistake is made by the jury in assessing the dollar amount.
Sure.
But you've at least taken a chance at getting things corrected without going through the appeal process.
And without having to necessarily go through a new trial.
Exactly.